OK， 2015年版權特許機構註冊修訂規例、2015年商標修訂規則及2015年註冊外觀設計修訂規則小組委員會而家開會，隔日又夠鐘。而家進行呢，就有關上述3條法案嘅規則嘅小組委員會主席選舉，請委員提名主席一職嘅人選，有效提名由1位委員口頭提出，並須由至少另外1名嘅委員口頭附議，並獲該提名委員接納。
To be seconded by another member. Nominations, please. Mr. Charles Mock. Do you accept? Yes. Mr. Dennis Kwok seconded. Any other seconders? Mr. Wong Ting Kwong does not accept. Mr. Ma Fong Kwok, I do not accept. So 2 invalid nominations. Any other nominations? Mr. Charles Mock, you are the chairman. Let's invite the administration to join us. I don't think we need an introduction. Ms. Leung, are you going to take us through the amendments? Thank you. Let me first give you some background information about the 3 amendments, regulations, and rules. The Intellectual Property Department conducted an exercise to review the cost recovery, and under the principle of user-pays principle, we propose to revise the fees so that all the registries will recover the full cost of providing the services. They are namely the trademarks registry, design registry, and also copyright registry. In relation to patent registry, we do not propose a revision. On the 16th of December 2014, we went to the the Economic Development Bureau, and it was gazetted. That is in relation to the 3 sets of amendment rules. They were gazetted on the 30th of January this year. In relation to the copyright licensing bodies registry, we have a set of revisions. They are respectively 12% and 58%. We will be able to recover full cost. In relation to trademarks registry and design registry, we do not to recover full cost for every item because we would like to encourage the registration of intellectual property and the use of IP. So the application fees will be kept at a low cost, below full cost recovery. We hope to maintain our competitiveness. We set it at an affordable level for companies to make the applications. In relation to renewal, it will be significantly above the recovery level. We propose to follow the same policy. That is, when we will use the renewal fees to subsidize the application fees. For registered intellectual property, if it's no longer in use, we would encourage non-renewal. That's why we have significantly higher renewal fees so that companies will not renew these rights. We found that the trademark registry cannot fully recover its cost. The current cost recovery rate stands at 87.7% when it comes to designs registry. The current cost recovery rate stands at 126.9%. When it comes to patents registry, because of the principle I just mentioned, we propose to increase application for patents registration by 54%. We have compared the fees in Hong Kong with other places. Compared to Singapore, Australia, and UK, we are still lower. We're either lower than theirs or similar to theirs after the revision. When it comes to renewal, because of streamlining and automation of the procedures since 2005, our cost has been decreasing. So we propose that when it comes to renewal, there will be a reduction of 11%. It will still be significantly higher than the cost recovery level. The renewal fees will continue to be main source for the trademarks registry, and it will also continue to subsidize the application fees of trademarks registry. Well, there is also the service of search for records and request for registrability. The cost recovery level currently is very low, about 20%. There is a flat fee of $200, regardless of the number of classes of goods or services requested. It can be 45 classes of goods and services. It's only a flat fee of $200. In 2014, we found cases when the applicant asked for a large number of classes of goods or services, We would like to adjust the fees so that we can bring it to a closer level to cost recovery and at the same time discourage abuse. There will be 100% increase for the first class, that is, it will be brought up to 400, and if there is more than one class, there will be an additional $200. Whether it is for preliminary advice or search of records, or both, for each class, there will be an additional $200. When it comes to the designs registry, as I said, that the current cost recovery level stands at 126.9%. And the renewal fees is significantly over the cost recovery level. It is used to subsidize application fees. When it comes to renewals, we have also used automation and we have streamlined the procedures. So we propose to reduce the renewal fees by 36%. Just like trademarks, it will still be significantly over the cost recovery level and will continue to be used to subsidize application fees. We have spoken to stakeholders, including professional bodies, including the Intellectual Property Committee of the Law Society, Hong Kong Institute of Trademark Practitioners, Asian Patent Attorneys Association Hong Kong Group. We actually have regular meetings with them. In November, there was a special meeting to consult their views on the proposal of fees revision. We explained to them that, if the renewal, they said that if the renewal fees is not significantly increased, then application fees can be slightly increased. During and after the meeting, we did not receive any strong objection to the proposals. On the 26th of January, we received from the Law Society a submission on the revision of fees for renewal and application of trademarks. They have indicated a strong objection. They proposed that the application fees should be increased slightly by 28.5%. But we think that 28.5% cannot recover cost without changing the renewal fees. The Asian Patent Attorneys Association Hong Kong Group and the Hong Kong Institute of Trademark Practitioners gave submissions to the committee in support of the Law Society's submission. We have taken into account the submissions of the Law Society and the supporting views of the other two bodies. Well, we would like to encourage merchants and IPR owners to register. And we would like to keep the fees low while recovering full costs. But we have not revised the fees for the past 10 years. Yes, it may be over 50%, but the actual increase is only $700.
And $700 is a fee for a 10-year registration of trademarks. And even for renewal fees, after reduction, we're talking about a relatively minor reduction by 11% only. And the major source of income that's brought about will be used to subsidize the application fees. So we maintain that our fee revision proposal is a reasonable one. And in relation to the Hong Kong Law Society and the other two professional institutes, we responded to their views on the 5th of February in writing. So, Chairman, that's more or less the background of this proposal. I urge members to support the fee revisions, and I'll be happy to take questions from members. Thank you. Thank you, Ms. Leung. I'll see if members have any questions. Mr. Mao Fung Kwok, followed by Mr. Sin Chung Kai. Thank you, Chairman. Well, I have read the administration's paper, and this matter has been discussed at the panel meeting. So I am not against the fee revisions based on the user pay principle to recover costs. However, if the application fees for registration of trademarks are raised, then the threshold for SMEs would be higher, and I'd like to know the impact. I wonder if the government has made any assessment on this, or whether such adjustment would discourage them from registering their trademarks. So that's the first question. Second question, according to the administration's paper, the applicants can inspect the registry online. On the other hand, the government also says that there have been abuses. So if that can be done conveniently online, why would applicants make application and pay a fee? What are the real reasons? Instead of going through the application online, conducting the checks online, why would they come to the registry and pay a fee? Now, our proposed fee is $1,300 for application fee, and the fees will go up by $700 to $2,000. That's for class 1. For second class is $650, and the fee will be raised to $1,000. And according to our experience from the statistics collected, usually applicants are concerned with the two classes. So if an applicant applies to register two classes, and after the fee increase, it will be $3,000. So that's about $1,000 more. But $1,000 extra would mean registering two classes of goods or services. And as I said just now, the period will be one of 10 years. So we're talking about $100 more a year. The percentage might seem high, 54%, but in terms of business, we're talking about an annual extra cost of $100 for two classes of trademarks. And we've also made comparisons. In UK, Australia, and Singapore, their application fees are still higher than ours after fee revisions. So normally our fees are set at a level lower than theirs. Well, but maybe due to change in the exchange rate in December, their fees were higher than ours in January because of changes in the currency rate. The gap has somewhat narrowed. So To answer Mr. Feng's question, we have been in regular liaison with SMEs. We give them seminars and training courses, and we've also asked the SMEs about the fee hike, and they only ask for more moderate increase instead of objecting to any increase. So we're talking about $1,000 more in terms of their annual costs per year, per 10 year. So the impact is not significant. Second question. Mr. Ma Fong Kwok asked about the online index service, and that is this service is free. Anyone can do that at home. But if you're not a professional, say if you'd like to apply for the registration of a trademark of, say, a pear, then you could just key in the trademark and see if that name has been registered. However, according to the law, there are restrictions on the use of similar trademarks that may cause confusion among the public. And if the person is not sure whether the trademark that he wishes to register is similar to any other trademark, he could seek the service of the trademarks registry. Instead of paying $1,300 at present, they only need to pay $200, which is a flat fee for advice from us on whether there could be problems if he applies for this class, and whether somebody has registered that trademark before, and then our officer will check what trademarks have been registered, belonging to which classes, and then the officer will consider whether the goods are similar in nature for the applicant to make a decision. So if he comes in person to make an application, we will give him advice. And we also received 7,000 such applications last year requiring preliminary advice. Another question, be it any SME or any applicant, if they're not sure, they can seek advice from you to conduct an assessment. So in future, if there is any dispute over IP-related matters, or if they're accused of copyright infringement, would this constitute a defense because they've sought advice from you? Chairman, on preliminary advice, it is mainly about the advice given to applicant when they first approach the trademarks registry, whether there would be any objection. If, according to our preliminary advice, that trademark cannot be registered because somebody has registered that trademark already, then he should change his trademark to be registered or not to register for that class of goods or services at all. And it's up to him to decide whether to register the trademark. While he's considering registration, he can seek preliminary advice from us to see whether he could use that trademark for his business. So it's different from any IP disputes in the future, where the court will then look afresh the similarity of the two trademarks. There is no binding effect as far as our preliminary advice is concerned. No follow-up, Mr. Ma Fong Kwok, Mr. Sin Chung Kai then. Well, I did pay attention to what you said just now, but you seem to be going a bit too quick. I'd like to know the view of the Law Society or the Bar Association. Well, perhaps we have had papers at the panel. Do we need a copy of the submission for members' reference? Ms. Wong, what is the counter-proposal given by the Law Society about the amount of fees? Well, the major concern of the Law Society is that in terms of renewal fees, no one has asked for a reduction. Although they understand that our renewal fees are set at the level exceeding the full recovery level. And yet, because no one has proposed that we reduce the fees, they question, by doing so, whether the value of the trademarks and designs registered would be affected, which in turn would affect the value of the intellectual property. And with cheaper renewal fees, some IP products which originally may not be renewed, would be renewed. Well, on the designs, we do not conduct substantive checks, whereas for trademarks we do. So with more and more trademarks on the registry, there will be an increase in the workload of officers who would be required to check through the registry for similar trademarks. And their concern is that your workload is already quite heavy, and if there are more and more trademarks registered, then your workload will be increased. And if the renewal fees are not reduced by 11%, then the application fees could be raised slightly. And our proposal is to increase it by 54%. And there is a question on whether this would pose a hurdle for SMEs, deter them from registering their trademarks and designs. And that's a concern. Basically, our principles are the same. We do not want IPs no longer in use to be renewed, and we're talking about a reduction of renewal fees of $330. So for the first renewal, it would take about $2,000, $2,000 or $3,000. Isn't it 3,000? I'm sorry, after reduction is $2,670. So $2,670 after reduction. Our consideration is whether those originally not intending to renew the trademarks or IPs would do so, but this is not a small sum. We're talking about $2,670 for the first renewal for each class. And we don't think that there will be any direct relations between the fees and the value of the IP. What's the period of renewal? 10 years. The first application for registration would go for 10 years. So what is the level of or percentage of subsidy that you anticipate, or how much cost will be recovered? Renewal fees. It's now pitched at about $2,000, $2,500 plus, and that's the full recovery level. After reduction by 11%, it means the recovery rate would be at $2,002 plus, and the rate is about 38.6%. And after raising the fees, the recovery rate would just be some 50%. So we're still subsidizing quite substantially. And as I said just now, for the designs registry and the trademarks registry, renewal fees remain to be the major source of income. In 2014-15, well, in fact, you don't need to do anything for renewals. Well, most of the applications for renewals are made online. So if they submit all the information, that can be done.
So there's an instant confirmation of a successful renewal. We provide this service starting from 2005. So the cost is indeed very low. Mr. Sin? But it's not stated in the document. It's not being photocopied. You just have to wait a second. Ms. Sin Ho. Over a period of 10 years for a business, yes, my microphone's on. So the monetary amount itself is small. But I'd like to ask, in the trademark register, how many of them are active? How many of the trademarks are active? Because you would like to reduce the number of inactive trademarks. This will reduce your workload when you are going through the register. And if you want to enter the market, and if your trademark is similar to an existing registered one which is inactive, you will not be allowed to use your trademark, and that will be regrettable. So do you have the figures? How many trademarks are no longer active in the market? But the slot is hot. And how many applications are rejected because they are similar to an existing registered trademark? Ms. Leung, do you know? We won't know, because once it's registered, they don't have to tell us whether it's used. But there is a mechanism in the ordinance to prevent abuse. If the registered trademark is not used for 3 years, then anyone can make an application to cancel that trademark. This is to prevent someone hogging the trademark without using it. Do you have the figures? Yes. For 2014, as at the end of that year, there are altogether 340,000 valid trademarks registered. In 2014, for partial cancellation or full cancellation, by partial cancellation, I mean, well, say there are 4 types and one of them was cancelled. For partial cancellation, there are 40 successful cases out of 340,000. You said 340,000, yes, registered trademarks, and in 2014, 40 of them were cancelled because they haven't been used. There is no sign that there are lots of abuse cases. But maybe they are hogging the trademark, but just that no one's interested or no one challenged it. My first reaction is that, well, there is abuse, but it's just that no one pays attention. Are there a large number of cases when they do not renew after the end of 10 years? Or is it the case that, as the Law Society said, that, given the low cost, they will automatically renew it? So for the 40 cases, it's upon application that they've been cancelled. And I also asked for another piece of information. How many cases of rejection because the trademark is similar to an existing one? And in these cases, did you tell them that these are the trademarks that are similar to yours, so that the applicant can find out whether any laws have been broken? It will save your department a lot of work. I will answer one by one. Cancellation applications. We will only cancel a trademark when there is an application. It may be done by various reasons. In 2014, there were 40 cases because the trademarks were not used. But there are some other cases, say for example, when it was used, it would cause confusion, but they are excluded from that figure. Out of the registered trademarks, how many of them would apply for renewal between 2011 and 2013? There are about 50% of them would come to make a renewal, and 50% of them will not. For each class is $3,000 is still cost. A reduction of 300 is small. Ms. Ho asked a question. How many cases of rejection there are because they are similar? We don't have that figure, but we have another figure. Of all the applications, about 20% of them are unsuccessful in the first round. So 80% of them are successful. For the 20%, it may be because of a number of reasons, similar to an existing trademark is one. No special characteristics may be another one. Say, for example, the trademark is clothes for clothes. Well, for similar cases, it will be lower than 20%. We will tell them the reasons. We have a detailed explanation explaining to them, say for example, your trademark is similar to which one in which category, in which class, or which is in conflict with yours in which class. Ms. Ho? Law Society and two bodies object to this proposed revision. What justification do you have to increase the fees and recover cost? Ms. Leung. Our policy objective is to encourage registration, so we're talking about overall cost recovery. We are aware that the percentage itself is scary, 54%, but in absolute monetary amount, it's actually small. We're talking about overall cost recovery for the entire registry. You may ask a smaller increase, say 90% of cost recovery instead of 100. In monetary terms, it's very small. Maybe just $100 or $200 for 10 years. But there is cost in every fees revision. We think it is a reasonable proposal. We have considered a number of factors before arriving at the decision. Well, it seems that the Law Society is not against an increase of 58%. They object to the reduction, but your answer was the other way around. They object to design trademarks, a reduction of 11% and 36%. So it's nothing to do with an increase in fees. They have given us a lot of justifications or their views when it comes to the reduction. And I've explained why they are so concerned. They are concerned that it may affect the value of the IPR and there will be a lot of unused ones on the register. We have considered those factors. The reduction is only about $300. And we have made comparisons with other registries, say UK, Australia, Singapore, because we have similar legislations. After the reduction, our fees are still higher than those registries. If you want to use a higher renewal fees as a deterrent, well, we are already the highest. After the reduction, we will still be able to recover costs around 2,000%. I think it's a matter of extent for the Law Society. But our fees after revision are still the highest. No, I just don't understand. The amount is small, and there are views from the sector, and I don't understand why the administration won't listen to them. They just told us that they have done a lot and they don't want to change. Well, if it's changed, the level of subsidy will be changed as well. Is there any adverse impact? I mean, the Law Society's proposal? Well, when it comes to the Science Registry, the Law Society asked to not revise the fees. Well, their cost recovery rate is 120%. Without a reduction, then we will be making more than we should. Their views is that when it comes to designs, there should not be any reduction, and the extra should be used to subsidize other registries. But that is not in line with government principles, because the income of one registry should not be used to subsidize another registry. And when setting a fees level, we have to abide by the user pays the cost recovery principle. So for the designs registry, the only fees that's above a cost recovery is renewal. So it's already used to subsidize other fees. For the other fees, say for application for design is 700 or so. If we reduce the application fees, we'll have to reduce it by 70% to drive down the cost recovery rate. For trademarks, I think it's a matter of degree. If we do not reduce the renewal fees and reduce the extent of increase, technically is feasible. But is it better than our proposal in principle? Well, for renewal, we already have a cost recovery rate of 2,000. We'll only ask for a reduction of 11%. The fees were set in 2003. And at that time, we did not have automation because it only started in 2005. And over 60% of the applications are handled by automation. Should we still use the basis when there was no automation? The ideas are the same, but I think it's different in principle. Yes, the amount is just several $100s, but there is no right or wrong. It's about reasonableness.
Well, let me interject. I have a relevant question. You said that you should not subsidize one area should not be used to subsidize another, but you cover a wide scope. For example, we'd like to, well, it's not certain whether the number of applications and the number of renewals may change or not due to change in the economic circumstances. And what happened and how would you handle the matter if you receive a huge income from renewals and applications? Well, the percentage of renewal accounts for about 50%, and our projection for next year is roughly the same percentage. If next year fewer renewal applications are received, then we may not be able to fully recover costs, and we just make our projections based on past experience. And when conducting the costing exercise, we take into account the cost of each officer dealing with each application. Now, would you have any report to find out how much income you've made, how much loss you've incurred? Yes, last year we completed the overall cost review. That's not a public report. It's just for our internal use when we look at the income and costs involved, and our accountancy colleagues help us with that. Now, let me supplement. It is the government's principle to recover costs, and that we need to abide by the user pays principle. And that's the policy for each government department. Each government department is required to do costing exercise to see if the fees charged could recover costs. And this is about internal fiscal discipline. And this is the overall government policy. On this occasion, because we have not made any adjustment in the past 10 years, the level of adjustment may be a bit too substantial. But we are just making adjustments in line with the changing circumstances. In future, we'll try to bring the level of fees closer to the cost recovery rate, and that's what we can do overall speaking in future. Mr. Sin Chung Kai. Well, I also read the Law Society submission. As far as the fees charged by government departments, I agree with the user pays principle. Even if it is for subsidizing other areas of work, it should be used internally. I don't think it's fair to have cross-registry subsidies. And I don't think the subsidy should be too substantial. You should try to strive for full cost recovery. Of course, there are submissions from the relevant bodies, and I think you should address some of their views. For example, renewal fees are charged at such a low level, and some people may continue to renew their trademarks, and maybe you should implement measures, for example, to show that the trademarks is really being used, and there could be more formalities. Proof may be required. But following the same logic, if you don't use the trademark, if somebody wants to strike you out, and then you can apply for renewal. So you could be more stringent. Well, say I pay some $2,600 to renew the trademark, and then without going through detailed inspection, the application can be processed online as long as I pay the renewal fees. But this is not very reasonable. The trademark should continue to be in use before it is renewed. So, in the same vein, those using the trademark may stand to be penalized. Instead of penalizing those who pay for renewal of trademarks in order to continue to own the trademarks but not using them, you penalize the actual users. So let's say if I have trademark, I pay $2,000 for using the trademark for 10 years, and I will charge me $600 more. Then following the same logic, I need to pay $4,000 for the villain, so to speak, who would pay a fee just to continue to own the trademark and drive out other users. Of course, we're talking about fees now, but when it comes to deterrent effect, some administrative measures should be implemented to ensure that the trademarks are still in use. As for lowering the fees, which may cause the IP values to drop, well, this is not our principle. Our principle is to recover costs. So this is the only thing we should consider. I don't have much view on the fee revision proposals. So your point is, for trademarks no longer in use, perhaps the administration or the department could take a more proactive approach. But we're talking about some 400,000 trademarks. Well, let me recap what I said just now. If this is your policy objective to tackle trademarks that are not really in use, and yet the owners of the trademark has continued to pay a renewal fee to own that trademark, then you should implement administrative measures to deter that instead of raising fees or reducing fees. But any administrative measure may involve legislative amendment, and this exercise is about fees or fee revisions. Well, this could be your policy objective, or this could somewhat meet your policy objective. But if you really want to tackle the problem of dominance of trademarks, then those actually using would indirectly be penalized. So is it one of your major policy objectives to deter abuse of registration of trademarks, or do you have any measures to prevent that? Chairman, I'd say this is one of our considerations. Two major policy objectives are, first of all, we encourage registration to protect intellectual property rights. So we try to lower our fees as much as possible, and this is one consideration. The other consideration is to deter trademarks no longer in use to be renewed. Before fee reduction, we're talking about $3,000. In other jurisdictions, the fees are charged at roughly, say in the UK or Australia and Singapore, at some $2,000, whilst our fees are charged at $3,000. So even after fee reduction, our fees are still higher than theirs by, say, a few $100s. So I can say our fee levels are quite similar. And the application fees would also be closer to theirs after the fee hike. So we try to subsidize trademark applications as much as possible. Although after reduction is still some $2,000, we are gradually narrowing the gap, bringing it closer to cost recovery. As for whether other administrative measures can be implemented, as I said just now, there is a procedure for withdrawal of application. In other common law countries, where there are the trademark registration systems, there are also other or the other, such similar measures. Say if it's no longer in use for 3 years, then someone can make an application to revoke that trademark. For example, if another applicant would like to use that trademark, then that applicant could apply for the revocation of the original one. So I think we take a two-pronged approach. On the one hand, we raise the fees, and secondly, we also have legal procedures. For the revocation, it's a legal procedure that an applicant can make through us or through the court. So it's for the applicant to make this application. Mr. Wong Ting Kwong. Thank you, Chairman. The DAB has also looked into the 3 fee revision proposals. We basically support them. We should encourage new trademarks to be registered. But what about those occupying the trademarked register without really putting the trademarks in use and deterring others from registering their trademarks? Well, those entrants will have a lot of hurdles to go through. Some trademarks are actually idling, not being put to use. So although the fare increase is moderate, it is a display of attitude. And also, apart from Hong Kong, globally speaking, in other jurisdictions, trademarks are usually registered in other jurisdictions altogether. So if there are fee hikes in many jurisdictions, then the cost for maintaining the so-called idle trademarks would be quite high. And usually we rely on intermediaries or lawyers in making the applications, and that would entail a fee as well. So instead of maintaining the idle trademarks, we may as well give them up. But of course, I understand the lawyers have their interest to defend. But from the perspective of SMEs, I think we should do away with idle trademarks and give more room for the young entrepreneurs. So on these 3 rules, I, in principle, support them. Although, to some extent, I think that some adjustments have been either too moderate or not moderate enough. Ms. Siho. Well, in short, I think the fee revisions would neither encourage nor discourage any applicant. However, the idle trademarks would deter new entrants from registering their trademarks. So I think this is the crux of the matter. Trademarks no longer in the market should be phased out as soon as possible. So I suggest that the administration consider this. The renewal period of 10 years should be adjusted so as to tie in with the legislative, tie in with the provision, which says that an applicant can file an application for revoking a a trademark after the trademark hasn't been in use for 3 years. So maybe you can consider changing the renewal period so as to tie in with the provision, which means 3 years.
Well, if that person is prepared to just close the business, maybe you just wait for the registration to expire and it won't be renewed. I think this will be better than using the fees. Using legislation is better because, well, in effect, it's only about several tens of dollars a year. And Mr. Wong mentions about registering in a number of countries, but we're still talking about several tens of dollars a year. There may be far-reaching implications because, well, the difference between 3 and 10 years is quite a lot when it comes to manpower. For other countries, I don't know whether they are 3 years or 10 years. Mostly 10. Even if it's done by electronic means, well, after 3 years, there's still work to be done because even if I use the same credit card, it will be a different number. So the work will have to be done once every 3 years instead of once every 10. If it's changed this way, I think the whole piece of legislation will have to be considered in consultations. My proposal is nothing to do with fees. It's the future. It's about the future, and I ask the administration to consider. Of course, you'll have to look at the 340,000 trademarks. Well, I heard that 50% of them will be renewed and 50% of them won't. You have to find the information. I think it's back to the original question. How many of them are disused? How many of them are in the way of new entrants to the market? I think the administration can reduce what they said into writing. If there are 340,000 valid trademarks, I think it's impossible for them to find out how many of them are disused. They will only check when someone wants it. Mr. Wong. Which Mr. Wong? Let me explain. Yes, for other jurisdictions, they will have a big database and no one will know how many of them are in use. I think it's about fairness, whether there is a mechanism to enable someone who would like to use it to find a way to use it. And we've explained that there is actually such a means. And it's also about whether there are a number of complaints that we've heard. We'll closely monitor the situation. And as we've said, that half of them will not be renewed. I think we have to further consider whether there are lots of cases when there are disused trademarks. Well, we were told that every year there are about 170,000 new ones, and there are number of rejections. There are only 40 cases of strikeout. How many cases of rejection because the trademark is similar to an existing ones? They told us that the total number of rejection is 20%, and they don't have the figure for similar trademarks. We want to narrow it down to similar trademarks so your workload will be much smaller. We don't ask you to give us the figure when this when this subsidiary legislation is endorsed, you can give us the figures later so that we will find out the magnitude of the problem. Mr. Wong Ting Kwong, you may not know about the actual operation. For a business, the registration of the sign of your company or a product, you won't just make one registration. Because in case my application is rejected, there will be 2, 3, 5, or 10. Because I expect some of them will be rejected. And I want to start my business and I want to have a logo. So the number of rejection cases will not reflect the actual situation. Maybe I submit 10 and only 2 are accepted. And I use 1 only. And maybe a few years down the line I realize I don't need another logo and I won't renew the other one. So I will submit a number of trademarks and I will keep those that are approved. Give us the figures, please, so that we know the magnitude of the problems and the causes. So it's different from what you have in mind. Your proposal of renewal of in relation to renewal of fees, it may have an impact of my future applications. I think you're beside the point. You just want to reduce the number of disused trademarks that are still registered. Maybe you will give us the information, the figures in writing, maybe to the panel. We will ask if the panel chairman will let us have a discussion. Mr. Sin Chung Kai, Ms. Ho, you have to be quick. Just 1 word. The Law Society and the 2 other bodies gave us this reason, that there are disused trademarks. They don't want disused trademarks to stay in the register. And we're trying to understand what the actual situation is. So we would like the administration to give us the figures. Give the figures to the panel so that we'll know whether it's actually a problem. And if it is, what caused it and what are the solutions? Of course, obviously, a revision of fees won't address the problem. Mr. Sin. Don't think you should use fees as a deterrent to discourage renewal. I think there should be, on top of that, administrative measures. I agree with Ms. Ho. If there is a review of the legislation, you have to explore ways to discourage or deter renewal of disuse of trademarks and, if necessary, cancel the trademark. You may also consider a short-term approved approval for a short term for the first registration. Say, for example, first time, 10 applications, you charge half of the fees. And say the next time, eight of them are not used, and say at the expiry of 2 years, and the other 8 will not be renewed. We don't want to see people who have the money to pay for renewal so as to keep the disused trademarks in the registry. May I supplement about the period of 10 years? As far as we know, other major trademark registries use 10 years. If we take into account international convention, the validity period of a trademark is usually 10 years. So that's the norm. We don't just think about our work. Workload is small because of the automation. And we remind the person who made the registration towards the end of the period. If it's left too late, the owner will have to find ways to remind himself to renew it. We know that using fees is not an effective deterrent because you may penalize innocent parties. We'll explore other means. We'll look into the 20% of rejection cases as to how many of them are related to similar trademarks. We have about 40,000 application cases. New ones, yes. That was the figure last year. It won't be practical to look at the figures in the past. We will look forward. We will collect data. And then we will study the data we've collected, say 1 or 2 years down the line, to find out of the rejected cases, how many of them are related to similar trademarks. Any other questions? Let's go to the amendments themselves. There are 3 sets. Registration of copyright licensing bodies regulation. We propose to revise the registration fees from 1,895 to 2,130. For renewal, 950 to 1,500. This is an annual renewal under the registration of copyright licensing bodies regulation. After the revision, we will be able to recover for every class. There are only 5 such licensing bodies. We've already alerted them about our proposal, and they have indicated they haven't indicated any views. The fees have not been revised for 10 years. They did not say they support us, but they did not make any comments. It's an annual renewal. We don't see any new registrations down in the pipeline. Next one.
Trademarks amendment rules. Starting from page 1, Rule 72, number 24 and 25A, fees in relation to official search of records. for particular trademarks. And for these rules, the $200 is a flat fee for all classes of goods or services, and our proposal is to increase it to $400 for the first class. For 25A, 25A is a new item. For additional class, we propose a $200 for each additional class. That's about official search of records. Rule 73 is about 25 and 25A, and that's about preliminary advice. At present, the fees for preliminary advice is $200. We propose to increase it to $400 for the first class and $200 for each additional class. So the fees are the same as the previous rule. That is, for the second class, if the applicant applies for official search and preliminary advice, then for the first class is $200. For the second is $400. No question? Please continue. Chairman, perhaps you should read the schedule. For the first item, that's to increase it from 1,300 to 2,000. And all other fees are related to application for trademarks. And it's proposed that the increase should be 54% to raise the fees to $1,000. As for the renewal fee, that's item 7. That's to reduce the fees from 3,000 to 2,670. For item 7, for the first class, the reduction will be from 3,000 to 2,670, and then a reduction from 1,500 to 1,340. The next category has to do with renewal as well. During different periods of time, there are different provisions on renewals, and yet the amounts are the same, from 1,500 to down to 1,340. Item 10, similarly, 1,500 reduced to 1,340. And then 24 and 25, I covered that just now, about official search of records and preliminary advice, $200 for each additional class. And then page 4, fee number 30. It has to do with trademarks as well. Again, the fees will be raised from 1,300 and 2,650 to 1,000 respectively. As for fee number 32, originally the fee is quite high, 1,500. And it will be raised by 54% to 2,300, and for the other the additional class, from 750 to 1,150, and that's all for the fee revision proposals for the trademarks registry. The next one is Registered Designs Amendment Rules 2015. The major amendments have to do with renewal fees. Schedule fee number 14 to 17. Each renewal will last for 5 years, and there will be a reduction of 36%. For the first renewal, a reduction from 1,230 to 790. And the second renewal of 5 years, 1,860 to 1,200. The third 5 year, from 2,740 to 1,760. In the fourth 5 year, from 4,170 to 2,690. So much from me, Chairman. Any questions? If not, then I should ask whether we should invite deputations to give their views. No. So I don't think we need more time, because the subcommittee is to report to the House Committee on the work of the subcommittee, and we need to prepare a report. Do we need to extend the scrutiny period? Can we make it in time? Well, because time is required for a report to be compiled, we may need to extend the scrutiny period. So after extension, the expiry date will be on the 25th of March. Well, we hope that it could come into effect before the end of March, because the costing exercise is for this financial year. So after extension, I think this is the date of the council meeting. So the 25th of March should be all right. So if there are no objections, let's follow this timetable. 25th of March, it will be tabled in the council. No, it will be extended on the 25th. Is that right? No, after extension, it will be tabled in the electrical in the council in 25th of March. How about report at HC? The Friday before the 18th of March. So check your calendar. So if there are no other questions, I think the meeting can be adjourned here. Thank you.